You had nothing better than that, meaning after all of the Fed work, all of the state work, all the local work, you still have no photos, no videos, no nothing to prove he was actually there. Everything you've got is assumption based on lack of evidence. This is literally based on the lack of, nothing else. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, we're going to start going through these. And like I mentioned in the last video, I'm not going to go through every single document on video and read everything the way that I normally do. Most of this is going to be very duplicative, very copy and paste. I know that I'm using duplicative a lot, but it's because that's the word that's being used in the actual argument that we're discussing. So yeah. Now, just like the defense was referencing other motions to suppress in specific motions to suppress, it seems like the state is also doing the same, using the same argument for other motions to suppress objections besides the one at hand at the time, which is the reason why I'm going in personally and just picking out the things that are new, what the very specific information is, and bringing it to you in as short a form as I possibly can. So this second one, because we did one in the previous video, the second one that we're going to be going over is their objection for the Apple account federal grand jury subpoena and the search warrant dated August 1st of 2023. So we need to keep in mind that there was a federal grand jury that failed. Okay. Then they brought it to a state grand jury. And one of the nuggets that we were given by Jay Logsdon in court, I guess it's been about a year or so now since we heard this. It's been quite a while. It was way before the change of venue situation. What he dropped, let slip, whatever he did, told us that at least 6 people in the state grand jury wanted more information because they felt like what was being given to them was extremely lacking. And then they were told that there wasn't any more. So I really hope that they can try to make it clear how we got here, because I don't understand how we went through a failed federal grand jury and then one where like half of the people needed more information and we still are where we are today. It legitimately makes no sense. Now, there's instantly a footnote, and we're going to go ahead and read the footnote. It states the defendant's filing refers to a contemporaneously filed motion for an order suppressing all evidence gathered by law enforcement from its search of his Apple accounts, primarily his iCloud account. However, the state is not aware of a separate contemporaneous filing, so the state's response is only to the contents of the defendant's singular motion to suppress and memorandum in support. So basically, they're saying that the defense is claiming something that the state has no knowledge of. And it sounds as if there wasn't any proof attached of this contemporaneous filing either, or else it would be something the state would know. So I don't know if they just like aren't attaching things because they're getting sloppy the way that we are learning here recently, because the whole argument that really threw me for a loop in the first video that we did about these yesterday on the 12th was that they have documents missing. They have exhibits missing on the things that they're turning into the court. And I had somebody in the comments saying, I can't believe you're just taking their word for it. Why would I not take the word of the state over just missing documentation? The court has all of this, and the state's not going to say, oh, the exhibits are missing if the exhibits are not missing, knowing that the court is going to be able to come back and be like, bro, the exhibits are right there. Like, are you for real? This is not something that we need to be playing, oh my God, I can't believe about. Okay, this is literal paperwork trail. This is paper trail. If it says the exhibits were missing, then they were probably missing, especially given the fact that the last couple of weeks have been showing nothing but sloppy work from the defense. Extremely sloppy. We have words missing out of sentences, misspellings, people being called by the wrong, technically their names, because there's multiple letters of the names missing out of the names. And we have dates being copied and pasted incorrectly. We have a December 2023 date whenever they're talking about the search warrants for his arrest back in 2022. And it's not like they're talking about January 1st, 2023. They're talking about December of 2022, but they're copying and pasting it with a incorrect 2023 date. None of them saw that. None of them thought to fix it. None of them. I'm just really hoping that this doesn't become a reoccurring theme in all of these, that there's missing documents, that exhibits aren't there, that this contemporaneous filing that they're talking about, it hasn't been presented, so the state doesn't know. I understand that the state's full of it, okay? But the defense cannot fight a fight with no information. And considering the fact that everything when it comes to how the DNA was apparently illegally obtained and all of that has been sealed to the public, we can only go off of what we can go off right now. And right now I'm seeing them not doing the job they should be doing for the fact that this is a literal life and death situation. Facts. Regarding the defendant's represented facts, the state respectfully refers the court to the defendant's exhibits A through D filed in support of his instant motion, as opposed to relying on the defendant's subjective summary and interpretation that begins at page 3. That almost sounds like to me he's saying, look at the exhibits and don't read anything that they wrote. But don't you have to do both to understand what's being argued? That's kind of stupid. The state's exhibits are as follows. Affidavit for search warrant for Apple with appended exhibits. Apple search warrant, order for return, Apple records obtained from the U.S. Attorney's Office, which show the limited scope of information, separate thumb drive. That's the federal stuff, the FBI stuff. Now, they're claiming that the Apple account information falls within the third-party doctrine, and they're claiming that this information is also part of their argument for their response to the Amazon warrants as well. It says that the search warrants dated April 26th and May 8th of 2023, the defendant seeks to suppress, was obtained by federal grand jury subpoenas and falls squarely within the third-party doctrine as recognized in Smith and Miller, and as the Supreme Court has continued to endorse in Carpenter, holding that persons have no reasonable expectation of privacy in phone numbers they dial because they necessarily share those numbers with phone companies to make calls. So because it's not your own actual personal information, and it's being stored in a device that technically another party, i.e. your phone company, has access to, then technically it's not your private information. Well, that can go for your photos, your text messages, your personal notes, like literally everything in your phone if that's how they want to play it. And it's the same thing apparently with banks, holding that persons have no reasonable expectation of privacy in banking business records because they voluntarily share that information with banks. Well, that's because they make it to where you have to. Like, in order for you to be able to literally like use your money almost anywhere these days, because we're in almost 2025 and cash really isn't king anymore. I mean, it is to a lot of people, but to like the big conglomerate companies, they really want you to have that plastic. They don't care if it's debit or credit, but they want you to have that plastic. And the banking system, it's already screwed up enough as it is. Like the fact that you can't just like walk in, if you do have this amount of money, you can't just walk in and want to pay a car in cash and be like, okay, I need to withdraw like $20,000 without them wanting to interrogate the crap out of you. I don't really quite understand how they can get away with that, especially if it shows that you have been like accumulating interest in a savings account and constantly putting like reoccurring deposits, and it shows a trail of how that money got there. But I see comments about that all the time. People that saved money for their kids' vehicles, for them to buy something with cash, or they just have the cash and then they want to pay cash to avoid the interest and all the credit stuff that happens. They get interrogated and basically get told, well, if you don't tell us what you're going to do with this money, then we're not giving it to you. Because as long as it's on that side of the teller, it's not your money. Second, as the defendant knows from review of the discovery itself, the information obtained from Apple was in no way a detailed and comprehensive record of the defendant's movements. So they're basically saying that whatever they think they saw, they're obviously misinterpreting it because this Apple report in no way says anything. So you're sitting there telling me that this Apple report that was used for a federal grand jury doesn't show anything specific at all about what the defendant was doing, yet it was still used? For what? The information provided was solely account subscriber information, i.e. emails, addresses, phone numbers, and the date the account was created. The information provided by Apple was devoid of any location information. The state was justified in relying on the information provided from the U.S. Attorney's Office, which simply confirmed that defendant had Apple iCloud accounts and that the email addresses / usernames associated. So you could have found that out like literally any other way besides the way that you just did this. This is allowed. Okay, but for what? If what you got from them didn't have anything evidence worthy. It's literally useless information. How many taxpayer dollars did that cost? As to the subsequent search warrant, the state established probable cause for the remainder of the items sought, as shown by the lengthy and detailed affidavit for search warrant. Boy, that thing is full of air, like a freaking bag of Lay's potato chips. Go sit down, Santa. They next argue that the defendant has not demonstrated the search warrant affidavits contain intentionally or recklessly false statements or omissions. In response to the defendant's argument under the affidavit submitted in support of the application for the issued search warrant, recklessly or intentionally omitted material information, relies on information gained in violation of the Constitution, and fails to provide probable cause for the requested search. The state refers the court to and hereby incorporates state's objection. Okay, so they're basically using using their objection for the Franks hearing and the IGG for this one, and they're not repeating their argument. The next one states the Alpha warrants incorporated the affidavit for probable cause and exhibit by a reference. The defendant next asserts that the search warrant fails to command law enforcement to search the accounts or contents of the iCloud. Does it? I could have sworn it didn't mention the iCloud. It was just like, it doesn't say specifically what you're looking for, whatever I felt like it did. But then again, I don't write search warrants and I'm not a lawyer, so I don't know what they're supposed to state. But I gave an example of what was the defense expecting to see on the search warrants. Were they expecting to see something specific as conversations between Bryan Kohberger and Kaylee Goncalves and or Maddie Mogen and or Ethan Chapin and or Xana Kernodle? Like, is that what they were expecting? Because it just referencing the homicide at 1122 King Road, to me, that's specific enough whenever you really don't know what you're looking for. But I know that it matters. I know that it matters. The Fourth Amendment to the United States Constitution requires that warrants must particularly describe the place to be searched and the persons or things to be seized. However, decisions must reflect the recognition that the Fourth Amendment's commands, like all constitutional requirements, are practical and not abstract. The Ninth Circuit held the courts consider the affidavit to be part of a warrant which could cure any deficiencies in the naked warrant when, 1, the warrant expressly incorporates the affidavit by reference, and 2, the affidavit is either attached physically or accompanies the warrant while agents execute the warrant. So, considering the apartment search, Dawn Daniels wrote her own boo-boo up, but then also attached Blaker's PCA. That sounds like it was supposed to be that way. But that's basically what the rest of this goes on to claim, is that the affidavit was attached to it, and so according to everything that the laws state, it was perfectly valid. In the case at hand, the search warrant expressly incorporates the affidavit for search warrant by reference. The language included on the face of the search warrant is Corporal Brett Payne, having given me proof upon oath this day showing probable cause establishing ground for the issuing of a warrant. But that's always been my thing too. Like, do these judges just take these cops and stuff's word for it, or do they actually say, okay, show me all the evidence instead of just reading the narrative? Like, do they actually have them physically show them surveillance footage, phone records, things like that, or are they just going off of the summary? I don't honestly know. The affidavit of probable cause, which is the Exhibit A, was the only proof presented to the magistrate. To read any other way would render the word proof meaningless and would be an abstract application not supported by Ventresca. As a result, the affidavit for search warrant and appended Exhibit A was incorporated by reference into the search warrant. Is Exhibit A something different? Like, I know that we read that, but I don't know why they keep referencing that. It's the defendant's Exhibit A, but is it the exact same thing, or are they referencing something that's sealed, and that's why they're just referring to it as Exhibit A? With respect to the second prong, the investigators necessarily had copies of the affidavit in their possession when they executed the warrant by emailing it to Apple, and they do have like portals and email systems that they do use for all that stuff. The effect of this is that the affidavit for search warrant and appended Exhibit A cure any supposed deficiencies in the naked warrant. Yeah, so basically they're saying the way that it was all put together was completely legal and justified, and there's nothing bad about it, but it really just all depends on the evidence that was collected and the story being told. Just because there's something attached correctly doesn't make it valid. Just because it follows the rules of whatever the protocol technically is for how to do what first before you do the next thing doesn't mean that the information in it was obtained legally, and it doesn't mean that the information in it is accurate either. The next argument that the defense had was that it failed to provide a command to search, but instead orders seizure, and it has no time frame. The defendant's argument fails to recognize that law enforcement must necessarily search for the items to seize them. Further, these items would have been inevitably discovered since the order signed by Judge Marshall on August 4th, 2023, directed law enforcement as follows. It is further ordered that said property or any part thereof may be delivered to any person or laboratory or laboratories for the purpose of conducting or obtaining any test, analysis, or identification of said property, which is deemed necessary by the custodial law enforcement agency or jurisdiction prosecuting attorney without further order of this court. I swear I did say the same thing, and it kind of goes back to what I've already mentioned. Like, I don't know how much more detailed it could have been, because it mentioned the homicide, and it mentioned basically looking for anything that could be related to the homicide. And in order for them to know if it's related to the homicide, they do have to first go in and look. I have my issues with the state because their evidence does not add up. But all of this stuff right here, the state is correct, in my opinion. There really wasn't anything incorrect about the steps But then again, everything that's important, which is how the DNA was apparently illegally obtained and all of the actual stuff, is all sealed. So this is all we've got for now. And then it goes on to talk about the Apple search warrant not being a general warrant and basically trying to argue the fact that it wasn't just a broad, vague warrant. It was pretty specific to the crime itself. And then it goes on into a whole bunch of case law that we're not going to go through on the video. Defendant's argument focuses on the second category, stating data compilation requested in the Apple warrant is too broad and that it makes no attempt at narrowing and results instead in a blanket request for everything available in 2 accounts with iCloud. Defendant's motion to suppress on page 14. Defendant relies on Wheeler versus State, a Delaware Supreme Court case that is not binding on this court. However, the Wheeler court held that warrants must be tested by courts in a common sense and realistic fashion, and reviewing courts should avoid a hyper-technical approach. The Wheeler court did not require a time frame to meet the particularity requirement, instead explaining that while investigators should generally include specific information known to them within the body of a search warrant, we hesitate to prescribe rigid rule and instead reiterate that warrants must designate the things to be searched and seized as particularly as possible. So this is where I'm sort of on the fence. So I've made comments about how I find it absolutely ridiculous that the Moscow Police Department had to file a search warrant to get information for the investigation from Coeur d'Alene Lab. Like, that's basically their lab. Like, that's the lab that they mostly use. So I don't really understand why that had to happen. It was basically their evidence, their case. It's pretty much like them asking themselves to get something from themselves. It's just weird to me. I find that over excessive. But then we have stuff like this where I sort of do agree with the state that it seems like all the protocols were in place for the way that things were worded. It just seems like technicalities that the defense is trying to fight that don't really exist, just because everything that they are fighting is sealed. Like, all of the actual information is sealed. So it's just like they're trying to just make sure they're covering all their bases because this at least puts something in the public eye. That's how I'm feeling about it so far. But it also, I guess, depends on the crime from how this sounds. What courts have made astoundingly clear is whether a search warrant satisfies the particularity requirement depends on the facts and circumstances of the crime for which the warrant is being sought. Well, this is a quadruple homicide. So I guess for them to go in there and just be like, we're looking for anything related to the homicide at this address, honestly, that being specific enough is fair to me. And then it goes on to state that the Apple search warrant, when considered with the search warrant affidavit and the Exhibit A, satisfies the particularity requirement. The Apple search warrant sought evidence of defendants' plans, thought process, research, locations, photos, or other pertinent information located on 2 Apple accounts shown to be associated with the defendant. To determine the parameters, the court should look to the particular facts of the case. Based on the affidavit of probable cause, we know several facts. No, you don't. Defendant was a suspect in a burglary and homicides occurring at 1122 King Road in Moscow, Idaho, on or about November 13th, 2022. And again, without labeling it, it's just Exhibit A, pages 1 through 19, which I'm guessing is the PCA. Defendant was the owner of 2 Apple iCloud accounts. Okay, but that doesn't make you a suspect. Detective Payne set out what information Apple captures in connection with the Apple ID. The 2 Apple iCloud accounts were accessed by the defendant leading up to the homicides. The 2 of them were? So one of them is not inactive. Okay. And following. So he accessed them both. But I mean, that's not uncommon, apparently, according to my comments, to have 2 iCloud accounts. But I'm guessing you wouldn't have to have, like, I don't know anything about iPhones. Do you have to have a second active, like, Apple phone account in order to have another iCloud account? Or can me, an Android user, go in and, like, create my own Apple iCloud account? I don't know how that stuff works. I can Google it and find it out. But I'd rather hear from you guys that actually use this iPhone stuff. So let me know how all that works down in the comments. But again, if it's normal, then him accessing both of his accounts on or before Christmas, that doesn't bother me. That doesn't bother me. That doesn't make you suspicious. The defendant was seeking an advanced degree in criminology and had studied cloud-based forensics prior to the crime. Exactly why anything being on those iClouds is out of the question, in my opinion. Out of the question. Defendant had attempted to conceal his location during the time of the crimes. That's not proven. That's not proven at all. They have had no one come out from the forensic download information and say that they have definitively proven that his phone was put in either airplane mode or was turned off. They have not proven that at all yet. Together, the above established probable cause to search the evidence of defendant's plans, thought process, research, locations, photos, or other pertinent information located on 2 Apple accounts shown to be associated with the defendant. I'm sorry, but you don't sit there and see that he's literally a pro in cloud-based forensics and think, well, this doesn't really sound right. Come on. Second, the warrant set out objective standards by which executing officers could differentiate items subject to seizure from those that were not. The seizure of items was limited to the crime for which the defendant was arrested. Exactly. They weren't going in there. But see, that's also the other thing, though. Because if, say, you do something crazy and they have to go through your phone and see if there's anything in your phone related to that something crazy. There could be a conversation between you and your kid, you and your partner, you and your mama, you and your boss, doesn't matter, you and your best friend. You could be writing your deepest, darkest secrets in a note memo or a memo app or whatever. Like, you could have something on your phone that's personal for you and you're innocent. You actually have nothing, that you have nothing to do with the crime. But in order for the cops to know that, and they have a search warrant for it because of stuff like this, they're now allowed to go in and go through all of your personal data that literally might not have anything to do with anything, just so they can see if it has anything to do with anything. It is a complete and horrible invasion of privacy if you are actually innocent. If you're guilty, then everything's fair game. But when it comes to this kind of stuff, that's the other on the fence thing, because you do want that protected. But then whenever you have somebody that is guilty and deserves whatever they're getting, you're like, damn, how do I view that? It sucks to be a human. Third, the government was not able to describe the items more particularly considering the information available to it at the time the warrant was issued. Detective Payne could not reasonably narrow the scope further. You had nothing better than that, meaning after all of the Fed work, all of the state work, all the local work, you still have no photos, no videos, nothing to prove he was actually there. Everything you've got is assumption based on lack of evidence. This is literally based on the lack of, nothing else. Since Detective Payne was seeking evidence that could be located in multiple formats and areas, and considering electronic data can be stored anywhere, it was impossible for Detective Payne to narrow down in advance the Apple areas that should be searched. As a result, if the court employs a common sense and realistic approach and not the hyper-technical approach the defense is suggesting, which honestly, I feel like the way that Hippler sticks to laws, he might actually go for this hyper-technical POV, maybe. The court should find the Apple search warrant passes the Teal test and sufficiently particular. Do you mean and is sufficiently particular? Y'all, I know that I am not in Idaho, but you can hire me remotely just to do your proofreading. I mean, come on. In summary, given the circumstances of this case, the Apple search warrant and its respective affidavit and Exhibit A are as particular as can reasonably be expected. So they don't want none of this suppressed. Okay. I read more of this one than I wanted to, but it's because the state actually gave a lot of their own words in this, and it wasn't so much copy and paste. Now, this one is 14 pages, and the rest of them are not this long, at least from what I've seen so far. Now, this is the one for the arrest warrant, and this one and a bunch of the other ones are pretty much going to be copy and paste, format, wording, everything that the apartment one was that we went over whenever all of these dropped. So I'm only going to read a paragraph or so out of this one because it's pretty much all going to be the same, the way the defense copy and pasted all of that stuff. The irony of all of this is so ridiculous. As an initial observation, the defendant's instant motion is unclear as to what arrest warrant he is referring to. The defendant's arguments in his instant motion appear substantively identical to the arguments the defendant propounds in his motion to suppress the Pennsylvania search warrant for 1119 Lambsden Drive, Albrightsville, Pennsylvania, in statements made for Mr. Kohberger's person and for white Hyundai Elantra bearing VIN number blah, blah, blah. Those motions all address search warrants issued and served in the state of Pennsylvania. The state is unaware of any Pennsylvania arrest warrant that would be subject to the same analysis. Adding to this confusion is the fact that the titles/captions defendant uses in the text of his instant motion all appear to refer to search warrant as opposed to arrest warrant. So they're using the wrong, specific word for it. The only mention of an arrest warrant is in the defendant's conclusion on page 7. To the extent the defendant is referring to his arrest in Pennsylvania, and to avoid unnecessary repetition, the state incorporates herein the state's objection to defendant's motion to suppress in memorandum in support of Pennsylvania search warrant for 1119 Lambson Drive. That's where it all starts becoming completely repetitive. Okay, this one is for the cell phone regarding the Moscow Police Forensic Lab warrant dated January 9th of 2023. Now, there's instantly a footnote, and it states defendant's filing refers to a contemporaneously filed motion for an order suppressing all evidence gathered by law enforcement from its search of the Seagate 2 terabyte external USB drive with serial number. There it is. However, the state is unaware of a separate contemporaneous filing. This is the same as the other one. Okay, so they're not aware of whatever extra stuff the defense is talking about, which I don't see how, but okay. And here we have pretty much the exact same arguments again. Defendant has not demonstrated the search warrant affidavits contain intentionally or recklessly false statements or omissions. The defendant raises its objection to the IGG, and again, the state incorporates the state's arguments in response to the defendant's separate IGG motion as opposed to restating them here. So again, they're like, oh, we already talked about this in the other one, so we're just not going to do it again because we've already said it. Basically, what I think they're doing here is not wanting to have Judge Hippler tell them the exact same thing that he told the defense. The search warrant incorporated the affidavit for search warrant and Exhibit A by reference. Again, not wanting to restate things here either. The cell phone and USB file warrant was not a general warrant. That's the same argument that they held with the Apple warrants. It's all the exact same argument. As applied to the Seagate 2 terabyte external USB drive search warrant, Idaho allows a search warrant affidavit to support the particularity requirement when the warrant references the affidavit for probable cause. When the Seagate 2 terabyte external USB drive search warrant is considered along with the affidavit for probable cause and the 20-page Exhibit A, the warrants are sufficiently particular and valid. In fact, forensic detective Lawrence Mowry set forth why he believed the defendant's cell phone would contain evidence of the crime. I mean, not really though. Not really, though, because you've got no definitive proof of anything. You literally have none. While the Seagate 2 terabyte external USB drive search warrant was broadly worded regarding each category of digital evidence listed, the search warrant affidavit and appended exhibit, most likely that A1, provide the particularity necessary to satisfy the three-factor test set forth in Teal. Same thing. Probable cause existed to seize all items. The specific USB drive with identifying serial number was listed. The scope was expressly limited to November 13th, 2022 homicides. But again, you have to go through every little bitty thing to see if anything might be related to that, just in case. Like, you don't have a choice. Second, the warrant set out an objective standard by which executing officers, okay, the exact same thing. Third, the government was not able to describe the items more particularly. Yep, the exact same thing. And them just claiming, don't do this. No, please don't. Okay, now we're going to go on to the Elantra. And again, saying, look at these exhibits instead of going over the summary and interpretation written by the defense. That's wild to me. Okay. And now this is telling them to go and look at the Lambson Drive information so that it doesn't have to be repeated here again. Same situation pretty much here. Now, it looks like they actually let Bryan Kohberger have this one, standing. In response to the defendant's argument beginning on page 5 of the instant motion regarding whether the defendant had a reasonable expectation of privacy in his vehicle located at his parents' residence, the state does not dispute that the defendant has this standing. So does that mean what about the search warrant then? But this is all the exact same stuff they use in all of the other ones. There's nothing specific in here. And again, the state respectfully refers the court and incorporates herein the state's separate responses to the defendant's Frake motion and motion to support IGG, and basically just says, we wrote it over there, go look at it over there. Now we have the first warrant, the AT&T first warrant. Now this one's 8 pages. So let's see what's actually specific and different. Now this footnote seems to be on all of them, and the only thing that gets changed is the specific. But the theme is about this contemporaneous filing that the state doesn't have any idea about, that the defense keeps talking about. As the defendant correctly acknowledges, he has a privacy interest in his AT&T account records. As such, the state sought and was granted a search warrant to review those records. Okay. And then it says, go read what we said about the Franks motion. Okay. And then again, just like Apple, the AT&T warrant is on a general warrant. And then it goes on to talk about State versus Wilson, which is a big case they've referenced here quite a bit. Now, this gives a little bit of synopsis of this story. So let me just go ahead and read this so that we know why they keep referencing this case, or at least the details of the case. In Wilson, a man was shot and killed at an apartment complex. After investigating at the crime scene, officers determined the shooter was a black male driving a teal 1990 model Ford Aerostar van with a missing hubcap. Using a license plate reader system, officers located a matching vehicle a few miles from the location. Wilson was the registered owner of the vehicle and was arrested. Pursuant to a search warrant, officers located 2 cell phones belonging to Wilson. An investigator subsequently sought a second warrant for a forensic examination of the cell phone based on a search warrant application. The magistrate issued a warrant for all stored electronic information, including but not limited to user account information, stored phone information, images, text messages, videos, documents, emails, internet activity, call logs, contact information, phone book, or any deleted data. Deleted never means deleted, baby. The search warrant included pre-printed language with check boxes from which officers checked which crimes the investigators believed the cell phones were used in the commission of. The Wilson court held the warrants complete, those absence of limiting language distinguishes it from the other warrants we have upheld in prior cases based on the presence of so-called residual clauses or other limiting language. The court took issue with the simple listing of crimes as the limiting instruction. The Wilson court noted a warrant that stated cell phones to include all data contained therein, which are being possessed in violation of Georgia laws. Oh, that's interesting. That's Georgia too. I don't know. But according to these Georgia law, the 16-5-1 for murder, it was sufficient. Further, messages, photographs, video, contact, and other application data or any other evidence of the crime of murder were sufficiently particularized because it limited the search to items reasonably appearing to be connected to the victim's murder. But according to everything that we have heard from the actual people that have studied the case and know the evidence, there's no connection. There's no connection. Now, the defense is using that as an argument, as like, hey, this is what happened in this case, and now we're using it as reference for what we believe should be happening here. But the state is claiming that the Georgia Supreme Court's decision in Wilson has no factual or legal bearing on this Idaho case. First, the warrant application was not a simple check-the-box form and was supported by a substantial probable cause affidavit. You mean the one that you literally already told us was completely, like, redundant now? Are you for real? And now we're going to pretend like you didn't say that? Let's just not. The defendant argues the only limiting factor was the reference to homicides in this case. However, this ignores the actual language of the warrant. The actual language of the warrant, which is an exhibit, limited the evidence to the crimes of homicide at 1122 King Road, Moscow, Idaho. That's what I said. Like, it had the time, it had the time frame, and it had the address. I mean, I don't know really how much more specific they could have possibly gotten at that time. I feel like it was worded the way that it probably should have been worded. The AT&T search warrant, when considered with the search warrant affidavit and Exhibit A, satisfies the particularity requirements. And this is pretty much all the exact same stuff they used in the previous argument. They just switched out the words as needed. They're mentioning the IGG again, but then stating, in order for us to not restate anything, just, it's over here on this separate IGG motion. Okay. Now this is for the Pennsylvania search warrant for Mr. Kohberger's person. It's only 4 pages. So they're probably going to say, in order for us to not repeat ourselves, go look at this other one. Yeah, they're talking about the one for 119 Lambsden Drive. It's over there. It's over there. And it's also in the Frank's motion stuff. And it's also in our response to the motion to suppress the genetic information. Just go look over there. This whole thing refers the court to defendant's Exhibit A and B filed in support of his. Yeah, just go look over there. Applicable law. Yeah, go look at the Lambsden one. Okay, and then we finally get to the valid search warrant. Let's see if there's anything new in here. Yeah, they've used this before. By way of preliminary response, the state notes that Idaho law clearly states that if a search is conducted pursuant to a warrant, the burden of proof is on the defendant, unlike the burden of proof being on the state to prove that Bryan Kohberger actually committed these homicides. And more, go read this other one for the rest of our information. Okay, that one's done. This one's for the pin trap and trace device. It's the normal 5 pages. So I'm going to assume they did the same thing here. Yeah, it's the exact same footnotes. And then we have, yeah, that's pretty much the same. So basically, they're saying that they agree that Bryan Kohberger or anyone else has their right to privacy, but that's why they obtained a warrant, because it gives them permission outside of getting permission from the person. It gives them permission to invade that privacy is their basic fight. But still, they claim his argument fails. And again, with the AT&T warrant not being a general warrant, so yeah, it's going to be pretty much all the exact same stuff. The warrant set out objective standards by which executing officers could differentiate items subject to seizure from those that were not. A, the seizure of items was limited to the crime for which the defendant was arrested, the homicides at 1122 King Road in Moscow, Idaho. And B, the warrant was temporarily limited to the time June 23rd to 2022 at 12. So does that mean at noon? Because that's not how you claim midnight in military time. So I'm going to assume that meant midnight. So real-time data, i.e. present time. And then again, with how the government was not able to get any more particular. And they are claiming that suppression is not warranted like they've done on all of them. And then same. Okay, this is the last one because all the rest of the documents, it looks like it's big, right? Like it looks like it's a lot. But it's literally just their motions to seal, which means that they're going to all look like this. Let me just go ahead and pop this one up real quick. They're all going to be the exact same 3 pages. The only thing that's going to be different is pretty much like the title and, wherever inside the document, it actually has to change the verbiage. But other than that, it's all exactly the same. So this one is for the search warrant for Mr. Kohberger's person, his own person. Now you would think, like you would have thought for the arrest warrant, that this would be the one where they got really particular and really specific. But again, it's just the same old same the entire way through. Don't read what he wrote. Don't read his summary and interpretation. Just look at the exhibits, and everything else we have to say is written over here on this other one. Yeah. Following the defendant's arrest in Pennsylvania, he was extradited to the state of Idaho, and a search warrant was applied for and obtained from the Latell County Magistrate Court for a search of the defendant's person. That's what we looked at. That's how we know that he was swabbed twice. He was swabbed in Pennsylvania, and he was swabbed again whenever he got over to Idaho by both MPD and the feds. And the feds swabbed him 4 times over in Pennsylvania too. So I wonder if Pennsylvania also swabbed him, since MPD, I know that it was MPD's case, but if the feds swabbed both places, I wonder if Pennsylvania did their own. I wonder. I am planning on going back over all of the information over on the actual Commonwealth of Pennsylvania website, where they have all these together, sort of the same way that the Idaho case of interest site is listed, because there's a bunch more details in there that we haven't gone over yet on this channel. But yeah, everything else is exactly the same. Whatever we have to say is written on this other one, and you shouldn't do this, please no, don't. Okay, so I'm about to wrap this video up, and it is 6:46 p.m. on Friday the 13th Central Time. I am showing you guys the page right now to show you that there's no more public documentation for us to go over, but if we go over to the case summary, you can see that tomorrow we should be seeing the 20th supplemental request for discovery. Tomorrow on Saturday the 14th, that one might actually be viewable for us to go over. We shall see. It is now almost 12:30 on December the 14th, and there is still no document viewable. But that's it. We were able to cover all of them in this one video, but I want to know what you guys think about all of this new information down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already, and please don't forget to make sure that your notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.